Ready, start. Thus, comma, it is clear that adherence to the rule of equality in public employment is a basic features of our constitutions, and since the rule of law is the core of our constitutions, comma, a court would certainly be disabled from passing an order of holding a violation of Article 14 or in ordering the overlooking of the need to comply with the requirements of Article 14 read with Article 16 of the Constitutions. Therefore, consistent with the scheme for public employment, this court, while laying down the law, has necessarily to hold the unless the appointment is in terms of the relevant rules and after a proper competition among qualified persons, comma, the same would not confer any right on the appointed, full stop. If it is a contextual appointment, the appointment comes to an end at the end of the contract, comma, if it were an engagement or appointment on daily wages or casual basis, the same would come to an end when it is discontinued. Full stop. Similarly, comma, a temporary employee could not claim to be made permanent on the expiry of his term of appointment. It has also to be clarified that merely because a temporary employee or a casual wage worker is continued for a time beyond the term of his appointment, comma, he would not be entitled to be observed in regular service or made permanent, comma, merely on the strength of such continuous, comma, if the original appointment was not made by following a due process of selection as envisaged by the relevant rules. Full stop. Para. It is not open to the court to prevent regular requirement at the instant of temporary employee whose period of employment has come to an end, or of advocate employee who, by the very nature of their appointment, comma, do not acquire any right, full stop. High courts acting under Article 226 of the Constitutions of India, comma, should not originally issue direction for observations, regulations, or permanent continuing unless the requirement itself was made regularly and in terms of the constitutionally scheme. Merely because an employee had continued under cover of an order of court, comma, which we have described as illegal employment in the earlier part of the judgment, comma, he would not be entitled to any right to be observed or made permanent in the service, full stop. In fact, comma, in such cases, comma, the High Court may not be justified in issuing interim directions, comma, since, comma, after all, comma, if ultimately the employee approaching it is found entitled to the and it may be possible for it to mold the relief in such a manner that ultimately no prejudice will be caused to him, whereas an interim direction to continue his employment would hold up the regular procedures for selection or impose on the state the burden of paying an employee who is really not required. Full stop. The courts must be careful in ensuring that they do not interfere unduly with the economic arrangement of its affairs by the state or its paras to lead and themselves the instrument to facilitate by passing of the constitutional mandates. Full stop.